Today's date is August 5th, 2011. Time in is 2:55 p.m. Today's business class lesson, this hour's business class lesson is called, it's going to be the effect of overly broad non-competition clauses. The courts of different states treat unreasonably broad non-competition clauses in different ways. Some courts will strike the entire restriction if they find it to be unreasonable and will refuse to grant the buyer or employer any protection. Others will refuse to enforce the restraint as written but will adjust the clause and impose such restraints as would be reasonable. In case of breach of an enforceable non-competition clause, the person benefited by the clause may seek damages or an injunction, a court order preventing the promisor from violating the covenant. Log on to this if you want to know more about non-competition agreements. Try this website, Business Owners Toolkit, Non-Compete Agreements, www.toolkit.com/small business guide /sbg.aspx NID equals PO55750. Exculpatory clauses. An exculpatory clause, often called a release or liability waiver, is a provision in a contract that purports to relieve one of the parties from tort liability. Exculpatory clauses are suspects on public tort liabilities. On public policy grounds for two reasons. First, courts are concerned that a party who can contract away his liability for negligence will not have the incentive to use care to avoid hurting others. Second, courts are concerned that an agreement that accords one party such a powerful advantage might have been the result of the abuse of superior bargaining power, rather than truly voluntary choice. Although exculpatory agreements are often said to be disfavored in the law, the courts do not want to prevent parties who are dealing on a fair and voluntary basis from determining how the risk of their transaction shall be borne if their agreement does not threaten public health or safety. Courts enforce exculpatory clauses in some cases and refuse to enforce them in others, depending on the circumstances of the case, the identity and relationship of the parties, and the language of the agreement. A few ground rules can be stated. First, an extraordinary exculpatory clause cannot protect a party from liability for any wrongdoing greater than negligence. One that purports to relieve a person from liability for fraud or some other willful tort will be considered to be against public policy. In some states, in fact, exculpatory clauses have been invalidated on this ground. Because of broad language, stating that one of the parties was received of all liabilities. Second, exculpatory clauses will not be effective to conclude tort liability on the part of a party who owes a duty to the public, such as an airline, because this would present an obvious threat to the public health and safety. A third possible limitation on the enforceability of exculpatory clauses arise from the increasing array of statutes and common law rules that impose certain obligations on one party to a contract for the benefit of the other party to the contract. Workers' compensation statutes and laws requiring landlords to maintain leased property in a habitable condition are examples of such laws. Sometimes a person on whom such an obligation is placed will attempt to escape it by inserting an exculpatory or waiver provision in the contract. Such clauses are often, though not always, found to be against public policy because if enforced they would frustrate the very purpose of imposing the duty in question. For example, an employee's agreement to relieve her employer from workers' compensation liability is likely to be held illegal as a violation of public policy. Even if a clause is not against public policy on any of the above three grounds, a court may still refuse to enforce it if a court finds that the clause was unconscionable, a contract of adhesion, or some other product of abuse of the superior bargaining power. Unconscionability and contracts of adhesion are discussed later in this chapter. This determination depends on all the facts of the case, facts that tend to show that the exculpatory clause was not the product of knowing consent. Let's increase the likelihood that the clause will not be enforced. A clause that is written in clear language and conspicuous print is more likely to be enforced than one written in legalice, and presented in fine print. Facts that tend to show that the exculpatory clause was the product of voluntary and consent increase the likelihood of enforcement of the clause. For example, a clause contained in a contract for a frivolous or unnecessary activity is more likely to be enforced than is an exculpatory clause contained in a contract for a necessary activity, such as medical care. You will see an example of the analysis of an exculpatory clause in the following McCoon case. McCoon versus Myrtle Beach Indoor Shooting Range Incorporated. 612 S.E.2D 462 parentheses S.C.CT.APP. 2005 parentheses. Christine McCoon went to the Myrtle Beach Indoor Shooting Range to participate in a paintball game with her husband and friends. Before being allowed to participate, McCain signed and dated a waiver that purported to release the range from liability for all known or unknown dangers for any reason with the exception of gross negligence on the part of the range. The language of the release provided in part, I, for myself, and on behalf of my heirs, hereby release and hold harmless the American Paintball League, the APL certified member field, the owners and lessors of premises used to conduct the paintball activities, their officers, agents, and/or employees, with respect to any and all injury, disability, death, or loss or damage to person or property, whether caused by the negligence of the releases or otherwise, except that which is the result of gross negligence and/or wanton misconduct. I have read this release of liability and assumption of risk agreement, fully understanding its terms. Understand that I have given up substantial rights by signing it, and signed it freely and voluntarily without any inducement. During her paintball session, McCoon used a mask provided by the range. During her play, the mask was loose and ill-fitting. She tried to have the mask tightened and replaced several times, and an employee of the range attempted to properly fit the mask for McCoon while playing in a match. McCoon caught the mask on the branch of a tree. The tree was obscured from her field of vision by the top of the mask. The mask was raised off her face because it was loose and provided no protection against an incoming paintball pellet. The pellet struck McCain in the eye, rendering her legally blind in the eye. McCoon brought a negligence suit against the range. The range filed a motion for summary judgment, alleging the waiver barred liability on its part. The court granted the range's motion and McCoon appealed. Judge Betty. McCoon maintains the trial court erred in granting summary judgment to the range on the basis of the exculpatory language and the release of liability signed by McCoon. McCoon asserts she did not anticipate the harm that was inflicted or the manner in which it occurred. Additionally, she contended the failure of the equipment was unexpected, and she could not have voluntarily assumed such a risk. We disagree. Express assumption of risk is contrasted with implied assumption of risk, which arises when the plaintiff implicitly, rather than expressly, assumes known risks. In the instant case, we are confronted with a defense based upon McCoon's express assumption of the risk. She signed a release from liability prior to participating in the paintball match. The courts of South Carolina have analyzed express assumption of the risk cases in terms of exculpatory contracts. Exculpatory contracts such as the one in this case have previously been upheld by the courts of this case. However, notwithstanding the general acceptance of exculpatory contracts, since such provisions tend to induce a want of care, they are not favored by the law and will be strictly construed against the party relying thereon. The release in the instant case explicitly and unambiguously limited the range's liability. The agreement was voluntarily signed and specifically stated: 1. She assumed the risks, whether known or unknown, and 2. She released the range from liability, even from injuries sustained because of the range's own negligence. It is clear McCoon voluntarily entered into the release in exchange for being allowed to participate in the paintball match. Additionally, she expressly assumed the risk for all known and unknown risks while participating and cannot now complain because she did not fully appreciate the exact risk she faced. We find the release entered into the parties does not contravene public policy. In Huckabee versus Confederate Motor Speedway, Inc., the plaintiff signed a waiver similar to the one above, which was required before he could participate in a sanctioned automobile race. He maintained his injuries were caused by the Speedway's faulty installation and maintenance of a guard's rail. As was found in Huckabee, participation in a paintball match is voluntary. in a paintball match is voluntary. If these agreements voluntarily entered into were not upheld, the effect would be to increase the liability of those organizing or sponsoring such events to such an extent that no one would be willing to undertake to sponsor sporting events. Clearly, this would not be in the public interest. Although our research reveals no South Carolina case that deals specifically with a release for paintball, other jurisdictions have found similarly worded releases to be unambiguous. Accordingly, we hold the trial court properly determined the release signed by McCune was sufficient to release the range from all liability in this incident, affirmed in favor of the range. That is today's business class lesson. It is now 3:06 p.m. 8 August 5th, 2011, 3:06 p.m.